Can Trump revoke your green card? What every green card holder must know. Fatima had been a green card holder for 11 years when she got a letter she did not understand. It looked official. It had government seals. It asked her about her travel history and her finances. She thought they were going to revoke her green card. In the current political climate, that fear is everywhere. So let me answer the question directly. Can Trump revoke your green card? I'm Kate Lincoln-Goldfinch, an Austin immigration attorney, and the answer is more complicated than yes or no. Some things the government can do, some things they cannot, and knowing the difference could protect everything you have built here. Green card holders have been nervous for good reason. There has been a wave of news stories, executive orders, and enforcement actions targeting people who thought their immigration status was settled. I want to give you real, accurate information, not to scare you more than you already are, and not to tell you everything is fine when it is not. The truth is somewhere in the middle, and you deserve to know exactly where the lines are. Denaturalization. Real, but rare. Let's start with the most extreme version of this question. Can the government strip someone of citizenship? Yes, but only in very specific circumstances, and it applies to people who have already naturalized, not to green card holders. The government can pursue denaturalization if someone obtained citizenship through fraud, meaning they concealed something they were legally required to disclose on their naturalization application. The process is not fast and not easy. The government must prove its case in federal court. There have been a handful of high-profile cases, and the current administration has signaled interest in pursuing more of these, but the legal bar remains high. If you became a citizen legitimately and disclosed everything truthfully, denaturalization is not a realistic threat to you. But it is worth knowing this process exists, especially if you have anything in your history that feels complicated. Green card revocation, what the grounds actually are. Now, let's talk about green cards specifically. A lawful permanent resident, what most people call a green card holder, can lose that status, but only on specific legal grounds. The government cannot revoke your green card simply because of a policy shift or a politician's statement. There are legal requirements. Let me walk you through the ones that matter most. Criminal convictions are the most common trigger for green card holders facing removal. Certain crimes can make you deportable regardless of how long you have been a permanent resident and regardless of how long ago the offense happened. The categories include crimes that immigration law describes as crimes involving moral turpitude, drug offenses, domestic violence, and a category called aggravated felonies, which sounds specific but actually covers a wider range of offenses than you might expect. Some crimes that seem minor or that receive minimal sentences can fall into these categories. If you have any criminal history at all, even arrests that did not result in conviction, even old convictions you believed were expunged, talk to an immigration attorney and get a full review done. I want to say one more thing about this specifically. The phrase expunged comes up a lot. People believe that if a conviction was expunged under state law, it no longer counts. In immigration law, that is not always true. Expungement under a state law does not erase a conviction for immigration purposes in most circumstances. So if someone told you years ago that an old conviction was cleaned up and you do not need to worry about it anymore, that advice may have been wrong in the context of your immigration status. This is worth verifying with an attorney before you have any contact with immigration authorities, before you renew any documents, and before you travel. Even DUIs, which many people consider minor, can create complications. A single DUI may not trigger removal on its own, but multiple DUIs, a DUI involving injury, or a DUI combined with any other criminal history can change that calculation. And in an enforcement environment where officers are looking for any grounds to take action, having a criminal record of any kind increases your exposure. Fraud or misrepresentation in your original green card application is another ground. If the government believes you obtained your status through deception, whether that means lying about your marriage, hiding prior immigration violations, or misrepresenting facts about your background, they can pursue revocation. These cases are more likely to be scrutinized when enforcement priorities change. If your original application had anything complicated, or if a prior attorney told you not to worry about something, it may be worth having a new attorney review what was submitted. Extended absence from the United States is a third major ground. A green card means you are a lawful permanent resident, but the permanent can create a false sense of security. If you spend more than a year outside the United States without a reentry permit, the government can argue that you abandoned your residency. Even 6 months can raise questions if your overall pattern shows that your primary life is somewhere else. We go deeper on this in the travel video, but for now, know that extended trips carry real consequences. The public charge rule. The public charge rule relates to whether immigrants have used certain public benefits. Public charge is primarily an issue at the time of admission or adjustment, not typically a basis for revoking existing LPR status. The current administration has tried to use public benefits history as a basis for challenging or denying immigration benefits, including green card renewals and applications. The legal landscape here has been shifting. Courts have pushed back on some applications of this rule, but the government has continued to pursue it in different forms. If you have used public benefits, whether for yourself or your children, and you are facing any renewal or application, talk to an attorney about whether that creates any exposure before you file. One important clarification. Benefits received by U.S. citizen children do not necessarily affect a green card holder parent's status. The use of benefits by citizens is treated differently under this rule than the use by the green card holder themselves. But the details matter, and the administration has pushed to expand the categories that count. This is another area where having an attorney review your specific situation before any renewal or application is a much better approach than guessing. What the current administration has actually been doing. Here is the current reality. The current administration has been more aggressive about immigration enforcement across every category. That includes not just undocumented immigrants, but also green card holders. According to recent reports, long-term permanent residents have been detained at airports, at border crossings, and in the interior of the country. There have been reports of green cards being flagged for review based on social media posts, past arrests that did not lead to conviction, and administrative errors in old files that nobody has looked at in years. One pattern that has emerged. People who have had green cards for 15 or 20 years, people who never thought twice about their status, are suddenly getting calls from attorneys asking if they have reviewed their file lately. Because something that was in a file in 2008 and was never addressed can surface now in a way it would not have surfaced 5 years ago. The enforcement posture has changed, not just in terms of who they are targeting, but in terms of how deep they are looking. That is not a reason to panic. It is a reason to know your own record before someone else knows it better than you do. None of that means the government can simply confiscate your green card for political reasons. The law still requires specific grounds and due process. But it does mean that the enforcement climate has changed, the grounds which would have been overlooked a few years ago are being actively pursued, and that green card holders who assumed their status was untouchable. What green card holders should do right now. Here is a concrete action list. First, review your record. If you have any criminal history, any arrests, any old convictions, get that reviewed by an immigration attorney before someone else identifies it first. This includes old matters, dropped charges, and anything you thought was resolved. Second, document your ties here. If your status is ever questioned, you want evidence of continuous residence. Employment records, tax returns, lease or mortgage documents, U.S.-born children, school enrollment, bank accounts, medical records. Start organizing that now and keep it somewhere accessible. Third, be careful with your travel. Extended absence creates real vulnerability. The next video covers this in detail, but talk to an attorney before any long trip. Fourth, think carefully about public benefits. The legal questions around this are unsettled, but the risk is real in the current enforcement environment. Fifth, and most importantly, if you are eligible to naturalize, do it. Citizenship is the most protected immigration status available in the United States. The grounds for taking away citizenship are far narrower than the grounds for revoking a green card. If you have held your green card long enough and you meet the other eligibility requirements, the current climate is a compelling reason to stop waiting. The naturalization process involves an application, a biometric appointment, an interview, and a civics and English test. Most people take several months to prepare, and the interview wait times vary by location. But the process is straightforward for people with clean records and solid continuous residence. If you've been putting it off because it felt optional, I want to be clear. In the current enforcement environment, citizenship is protection. It is the most concrete step a green card holder can take right now to secure their future in this country. the bottom line. The government cannot just take your green card because enforcement priorities have changed. There are legal requirements and legal processes, but those processes are being used more aggressively right now, and the risks that were theoretical 2 years ago are now real in practice. Fatima, for the record, had an attorney review her letter. It was a routine request for updated information. Her status was fine, but now she knows exactly where she stands, what would actually threaten her status, and what she would do if that changed. If you are a green card holder thinking about traveling outside the country right now, watch my video on green card travel safety before you book anything. The link is right here. If anything covered today raised questions about your own status, talk to an immigration attorney as soon as possible. At Lincoln-Goldfinch Law, we help green card holders protect what they have built. Visit lincolngoldfinch.com. Subscribe for immigration updates you actually need.